Can giving up legal rights count as consideration for a contract? This fundamental question is at the heart of one of the most famous and foundational cases in all of contract law, Hamer versus Sidway. Today, we're breaking down this landmark decision from the New York Court of Appeals. If you're a 1L student, this is likely one of the first cases you'll encounter as you begin your study of the theory of consideration. The story begins in the mid-1800s with William Story Sr. and his nephew, William Story Jr. It's a story about a family promise, personal restraint, and a major legal dispute. At a family celebration, the uncle made a striking proposal. If the nephew refrained from drinking, smoking, gambling, and swearing until he reached the age of 21, the uncle would reward his discipline. The promised reward was $5,000. In the 1860s, this was a small fortune, equivalent to over $150,000 in today's currency. The nephew fully accepted the challenge. He strictly followed the rules for several years, living a life of sobriety and restraint until his 21st birthday, fully expecting his uncle to keep his word. When the nephew reached age 21, he wrote to his uncle. The uncle replied, confirming that the nephew had earned the money and stating that he was holding it for him with interest. Responsibility had been met. However, the uncle died before the money was actually transferred. When the nephew sought the payment from the estate, the executor, Franklin Sidway, refused to pay, forcing the case into court. Sidway argued that the promise was not a binding contract because it lacked consideration. He claimed that the nephew hadn't actually given the uncle anything of value in exchange for the money. This brings us to the central legal issue. Was the nephew's promise to refrain from lawful activities, like drinking and smoking, valid consideration to make the uncle's promise legally enforceable? To understand the court's answer, we have to look at how the law defines consideration. It is the price paid for a promise, and it is usually found in a bargained-for exchange. Consideration can be a benefit received by the person making the promise, the promisor, or a legal detriment suffered by the person receiving the promise, the promisee. This distinction is vital. The rule established by the New York Court of Appeals is critical. Consideration exists when a party gives up a legal right, suffers a legal detriment, or provides something of value. In this context, a legal detriment does not mean something physically harmful happened. It simply means you restricted your lawful freedom of action in a way you weren't otherwise required to do. Sidway argued that the nephew actually benefited from the deal because his health improved by not smoking or drinking. Therefore, Sidway claimed there was no detriment and thus no contract. The court rejected this completely. They held that the nephew's personal health benefit was legally irrelevant to the question of whether a contract existed. What mattered was his legal right. By abandoning his legal freedom to drink and smoke for several years, because of the uncle's promise, the nephew provided all the consideration the law required to make the deal binding. The court also emphasized that it didn't matter if the uncle received any actual economic benefit from the nephew's sobriety. The nephew's forbearance alone was sufficient. The final holding, the promise was fully enforceable. Because the nephew restricted his freedom of action at the uncle's request, a binding contract was formed. The estate had to pay. This case solidified the benefit-detriment test in American law, proving that giving up something you have a right to do is just as powerful as giving a physical object or money. Hamer versus Sidway remains essential because it shifted the legal focus. It helped define the modern bargain theory of consideration that we use in courts today. It serves as a reminder that the law respects private bargains where parties trade their legal freedoms, regardless of whether a third party sees the value in that choice. Now, let's look at an exam tip for your 1L finals. Professors love to test the boundaries of consideration by presenting gifts that look like contracts. On an exam, always ask, did the promisee give up a legal right? If the answer is yes, you likely have valid consideration, even if the promisor didn't get richer. Don't get distracted by whether the deal seems fair or beneficial. Focus on the exchange. If there is a bargained for detriment, there is a contract. To recap, Hamer versus Sidway teaches us that consideration is about the exchange of legal rights. The nephew's forbearance was the price for the uncle's promise. Mastering this concept is your first step toward understanding the complex world of contract formation. Stay focused and keep thinking with structure. Legal intelligence, powered by AI. AI infrastructure for legal work and legal learning.